Welcome to this week's edition of Freedom and Prosperity Radio, the weekly radio news magazine we put together here at the Virginia Institute for Public Policy. My name is Joe Thomas, and we got a great program lined up for you this week. Wayne Cruz will be coming up in a little while from the Competitive Enterprise Institute, and of course, the author of the always fascinating 10,000 Commandments. But we lead off this week with right to work. It's one of those things that we sometimes take for granted here in the Commonwealth of Virginia, but the Supreme Court this past week agreed to hear the Janus versus AFSCME case. And joining us from the National Right to Work Legal Defense Foundation is Mark Mix. Mark, welcome back to the program. How are you doing, sir?
I'm doing great, Joe. Thanks for having us on to talk about this important case.
So let's first and foremost remind people when the Supreme Court agreed to hear something, that's not the beginning of the end, but maybe the end of the beginning for a case, correct?
Yeah, that's right. Obviously, the fact that the court agreed to hear the case is a step forward. These are fairly rare. The ability to get a case in front of the highest court in the land is something that doesn't happen very often. Fortunately, we've had some great luck at this over the last couple of years at the National Right to Work Legal Defense Foundation. But yeah, we expect that there'll be an argument in this case sometime in January or February, and probably won't hear a decision until probably the end of term in June. So there's a lot more work to be done for sure.
Well, it'll be just in time for the midterm elections then, Mark. But first and foremost, is this a sign that the Supreme Court, as it's now constructed with its new membership, is taking a more constitutional view of their role, and they're going to hear some cases that maybe they wouldn't have voted to hear before?
Yeah, I think so. But this actually, Joe, is an extension of a series of cases that we've litigated that have been brought up to the highest court, and they have made decisions. Back in 2012, we argued a case out of California called Knox versus SEIU, where the question on the table for the court was whether or not non-members of unions had to opt in or opt out of political expenditures and assessments that were made for things outside of the bargaining process. And that was a pretty big step forward. We won that case in 2012, and then in 2014, we won a case out of Illinois called Harris v. Quinn, Quinn being the former governor of the state of Illinois, and that was a pretty important case as it relates to First Amendment speech rights. And this whole argument goes all the way back to a case that we argued back in 1977, a case called Abood, where the question on the table was, can you compel someone to pay for speech to government?
Yeah, and that's fair, because union dues have, for the longest time, been used in these political campaigning situations, and there has been no recourse for a member to say, hey, I don't want that being used for that. So what we've eventually wound up with is this idea of this hive mentality where all union members think exactly the same, which is, I think, fascinating, because most of the union guys I grew up around were hardworking, blue-collar, kind of Reagan, if you want to call them Reagan Democrats, or just guys who wanted the government out of their life and to leave them alone. Yet it seemed like over years unions were speaking for them rather than about them.
Yeah, that's exactly right, and we are getting to the core issue of the First Amendment rights here. In a case, like I mentioned, goes all the way back to 1977. At that time, the Supreme Court ruled 6-3 with a very strong dissent by then Justice Powell about this very issue, saying that everything that government unions do is redressing their government. They're actually communicating and trying to encourage government to spend their resources a certain way.
Yeah.
And so that's exactly what we as citizens have the right to do, but no one should be in a position to be able to compel us to speak to government or have someone speak for us through compulsion. So it's a really, really great opportunity to come back and understand the First Amendment protections for these government employees. I mean, under current law, they can be forced to pay for someone to speak and for them to work for their own government, and that's just not really right. And we hope the court will get there and decide this on basic First Amendment questions.
Well, and it is essentially one of the reasons, even at the beginning of the union movement, folks as conservative as Franklin Delano Roosevelt warned against the establishment of public sector unions. based on the idea that, number one, a union is no longer constrained by the idea that their client could go out of business, which was one of the essential, things that we're still seeing in government, is that expenditures continue to go up. You couldn't do that to a car maker because eventually they just say, you know what, the hell with it, I'm not making cars anymore, and all those union jobs are gone. There's no negative pressure on the growth and the expenditures of a union when they're tied to government.
Yeah, you're absolutely right. And not only did Roosevelt have that position back in 1937 when they passed the Wagner Act, or the court upheld the National Labor Relations Act, but the AFL-CIO had the same position in the late 1950s. George Meany and the executive committee of the AFL-CIO indicated the same thing. You can't bargain with government. They said the only rights we have are equal to the same rights that citizens have to redress their government. Mm-hmm. But yet, we've come a long way since that position by Roosevelt and by the AFL-CIO to a point where union officials have dramatic power over the government sector. In 22 states, they can compel you to pay a fee to them in order to work for government, and that's just wrong.
So take us into the case a little bit. Let's do some specifics. Mark Mix, president of the National Right to Work Legal Defense Foundation. So take us into Janus and AFSCME. AFSCME, of course, one of the most preeminent public sector unions out there. And give us some of the details that the court will be hearing, starting with, what is on appeal as they're bringing it to the Supreme Court.
Yeah, Joe, this is kind of an interesting legal battle. It goes all the way back to January 2015, and actually it goes back to even before that. We argued a case, as I mentioned, called Knox in 2012, where Justice Sam Alito brought up the question of this jurisprudence that has existed since 1977 about how we grant, this violation of First Amendment rights to union officials. And so in Knox, the question was raised about this, and there was a question raised, should we look at this again? And then in 2014, we brought the Harris case on behalf of home health care providers in Illinois, and the court said, you can't compel them to pay for speech that the union does, quote unquote, on their behalf. And so Knox and Harris bring up this next question, where when Governor Bruce Rauner was elected in 2014, he immediately instructed the controller of the state of Illinois to withhold any money that would be taken from non-members and forwarded to union officials based on the decision in Harris, which was an Illinois case. Mm-hmm. Well, obviously that becomes a political question in Illinois because the union officials out there are very, very powerful. In fact, they created this whole thing by getting an executive order signed by then-Governor Bob Blagojevich, who basically signed this over and created this revenue stream for unions, and then they supported this campaign and blah, 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 blah. But anyway, Bruce Rauner instructs the controller not to withhold any of this money and put it in an escrow account pending this argument about First Amendment rights. And the Attorney General of the state, Lisa Madigan, decides she doesn't want to help the governor in this case. And we went to the district court there in the federal district court in Illinois, and they actually threw Bruce Rauner out of the case, saying he didn't have standing. But the good news is that we were able to enter the case on behalf of 3 employees of the state of Illinois, and the federal district court allowed us to intervene and represent the parties, which we now do. And so Rauner got booted out. We got in. We filed the case and argued it at the district court. We lost there, and then we lost the Seventh Circuit Court of Appeals, and obviously we filed a petition for certiorari with the United States Supreme Court in April. Actually, we filed the case in June of 2017, and they agreed just last week to hear this case in this term, with the expectation that it will be argued in January and a decision coming in June.
So, Mark, let's role play this out. Certainly a much more conservative lean to the Supreme Court now, though there are some wild cards in here. I don't want to count my chickens before they come home to roost.
Absolutely right.
But game plan this out. Suppose Supreme Court rules in your favor against AFSCME. What then happens? Because there's a real feeling that we're on a attack, and the only union sectors that are growing anymore are the public sector unions. We see what happens in places like Wisconsin, where despite the slings and arrows of outrageous misfortune, Scott Walker gets the union grip broken, and then Glorioski, what happens next? The sun comes up the next morning, and the state learns to get on without it. What is the next, and what are the repercussions of a Supreme Court ruling in your favor in this?
Well, obviously, if the court rules as we hope they will, this would be a protection for all non-member employees across the entire nation. So no teacher, no janitor, no police officer, no firefighter, no bureaucrat, no clerk. No one would be compelled to pay union dues as a condition of working for their government. That doesn't stop anyone from joining a union. It doesn't stop anyone from giving their money to a union if they deem that that's what they want to do. It simply says you can no longer be fired, and your job can't be conditioned on your payment of fees to a private organization. It's a very, very simple step forward, but a very important one. So what would happen, John, or Joe, you may recognize in 1993, the Virginia legislature passed and was signed by then Governor Doug Wilder a statutory prohibition against bargaining in the Commonwealth of Virginia.
Yep.
Obviously, that served very well, and as you know, one of the most powerful voices in the General Assembly down in Richmond is the unions, the teachers' union, the firefighters' union. But here it is. They're voluntary organizations. Mm-hmm. We are in a right-to-work state with with a statutory prohibition against bargaining, but yet their voice is heard loud and clear across the Commonwealth. So what we expect is the court to rule that this is a violation of the First Amendment, that no one can be compelled to have to force them to allow someone to speak for them, and that would put the unions in a position where they have to go out and recruit people and use the marketplace to serve people, and that's the extent of this case. But obviously there's a real question, just like Roosevelt said back in 1937 and the AFL-CIO said in 1959, there's a question of whether or not we should be bargaining at all in the government sector for points that you've made already, Joe.
Well, and I recall it was not all that long ago there was a big push to unionize Walmart, and Walmart competed against the union, and people were finding, actually, I do better. And then most recently, the Boeing plant in South Carolina, they tried to unionize it after trying to punish Boeing for trying to build excess 747s there, which was apparently some sort of violation of human rights. And I don't try to understand it; I just report on it. But and then they found that the union workers were doing better there without the union. The same is heard in Tennessee in some of the automotive factories where they're doing better without the union than with them. Is that part of the con that's still being perpetrated by unions, is that there's some greedy bunch of rich guys who never lift a finger to do anything, taking all your money and keeping it from you and keeping you in some sort of forced labor camp type arrangement? And if the American people really, despite what we may hear on the news, woken up to that?
Yeah, I think that's the case. And, there's obviously a place for organized labor in America's workplace. There will be a place, and there has been a place, but there's no place for compulsion. And that's really what the special privilege that union officials have relied on, and that's why they have to play politics so aggressively across the country, because their privileges are granted by government. And going all the way back to the 1930s, and then as they progressed into the public sector, into the government employment sphere, starting in the 1950s all the way to, an aggressive push in the 1970s. But yeah, they kind of lose sight of what's going on the shop floor because they're so focused on what happens politically. And if you look at their political actions, they are the biggest player on the political field. I mean, they spend more money than the Koch brothers, and they spend more money than Donald Trump. They spent more money than Hillary Clinton. They spent more money than George Soros and Tom Steyer in the last 2-year cycle. So It's a pretty big deal, and but it comes with that privilege of compulsion, and that's really the problem here. It's not the problem of unionization in particular. It's the problem of compulsion.
I've always felt, Mark, and I think we've talked about this in the past, part of the problem is that if you had a company that had this kind of grip on a marketplace, and in this case the marketplace is for the employees, that is of the employees, I guess, is really that if one company had all of the distribution or sold all the cars, we'd break it up as a monopoly. And these unions, what they do, and I watch it with the auto workers particularly, they'll strike against Chrysler and say, well, we'll shut you down and everyone will buy Chevys and Fords. And then they go threaten Ford with the same thing and wash, rinse, repeat. Yet there's never another union coming in saying, well, we like this contract, we'll take it. There's no competition in the union representation market. And I don't know if it's disingenuous to even think of such a thing, but wouldn't the rank and file worker be better served by a competitive labor market?
Well, I think absolutely, Joe. I think that's right. And, union officials asked for and got an exemption from the antitrust laws. So this idea of creating monopolies is something that they've done very effectively in industries like the auto industry and, interestingly enough, in the public sector.
Mm-hmm.
I mean, once the union official is granted the exclusive bargaining privilege on behalf of an employee, they are the sole voice in that marketplace. And once you get in, it's very hard to get out, and that's another area where the National Right to Work Legal Defense Foundation helps employees, literally tens of thousands of employees every year, trying to find a way to exercise their rights to get out of these monopolies. And it really is amazing how an institution that has gone from what was supposed to be a voluntary institution, according to the founder of the AFL, the American Federation of Labor, Samuel Gompers. He said the workers of America adhere to voluntary institutions. Anything else is a menace to their rights. And yet, from 1935 till today, they have relied on government privilege and power to compel people to support them. And that just doesn't seem like it's a very good business model, Joe.
Well, it also seems borderline socialistic. I mean, it becomes one of those, well, you may work harder than the guy down the line here, but you're going to get paid the same because this is what the union deems necessary. And I find that may be also part of what the American workforce is saying, hold on a second here. I worked all this extra time. I should be allowed to, reap the benefits of that.
Yeah, exactly. But union officials would tell you that that's a benefit to you, that they negotiate this one salary structure, this step up. The only thing that affects your salary is the amount of time that you spend at a particular workplace, not your performance. They would tell you that's a benefit. And that's one of the arguments that union officials make about the work that we do at the National Right to Work Legal Defense Foundation is that somehow we're interfering with all these benefits. Well, the scenario you just described is not a benefit to the person that's actually making more than the person down the line, but yet receiving less.
Absolutely. Absolutely, sir. So, one of the most compelling arguments that we have is that this idea of national right to work is somehow in the face of states' rights. And it's one of those places that conservatives kind of trip ourselves up on, this idea of if the federal government was to say we're a right to work country, that takes away states' rights. Address that a little bit, because I often find myself in conversations with conservatives where I agree that if New York doesn't want to be a right to work state, they should have the right to do that. But when we talk about government employees, I guess we do need to have a national voice on this, don't we, Mark?
Well, that's right. I think for the government employees, as the Janus case will hopefully present, this idea of First Amendment protections for these people that are compelled when they're redressing their government, I think that's an issue that's very important. As it relates to the so-called state action when it comes to private sector compulsory unionism, we have to remember the original sin of all this was the federal government creating a federal structure for compulsion back in 1935. There is no law on the books in California that compels any private sector worker to pay union dues to get or keep a job. That is a privilege that is granted to union officials from the federal National Labor Relations Act. So here's the point you make to people that say somehow this is a violation of states' rights. It's the federal government that imposes compulsory unionism in the private sector. Only a state that can, by affirmative action, outlaw compulsory dues and fees as a condition of employment, also a privilege granted by the federal government, can they pass a right to work law. So what we try to do, we have a one-page bill that's introduced in the United States Congress today that it wouldn't add a single word to federal law. It would simply repeal those provisions that authorize union officials to have a worker fired for failure to tender dues or fees. So I don't feel like we're violating any state law at all. And if people are consistent with that argument about states' rights, then we need to repeal the entire National Labor Relations Act and go back to a structure prior to 1935 where states would regulate labor policy. If that was the case, then New York, if they wanted to force every worker to pay union dues to keep their job, they could do that. But under the preemption doctrine of the National Labor Relations Act, we can't do that until we get that preemption doctrine out of the way. So that's why we continue to go to Congress and ask them to repeal the compulsion provisions out of the National Labor Relations Act. And we do that by simply not adding a word. We simply repeal that authorization that allows union officials to have a worker fired for failure to tender dues or fees.
So, and on that legislative level, the courage of a politician to face what Scott Walker faced in Wisconsin, for example, I don't want to say is scarce, but it's rarer than I would like it. Mark, let's just say that. What is the response you get when you go into congressional offices and start talking about this with our representatives?
Well, Joe, as you've talked about on your show many times, the lack of courage and backbone is no surprise when it comes to politicians. I mean, the one thing they think about most after they're elected is how to get reelected, and they don't want to make anybody mad. They don't want to, cause any trouble. They simply want to pass, insect of the month, and they want to honor state champion football teams, but they rarely want to stand up and take on issues that matter. Fundamental issues of freedom of association, of freedom of speech, issues that may or may not affect their political futures. But here's the secret to all this. When you look at the fact that we passed 6 new right-to-work laws in the last 5 years, not one politician who ran for office after voting for right-to-work in those 6 states, not one of them was defeated for office. Well, not Scott Walker, not Rick Snyder. Mm-hmm. It's a fascinating political exercise when you actually look at what's happened.
Well, you jumped ahead. That was going to be my next point. People who may recall that at the beginning of the 17-headed derby towards the presidential nomination, I was a Scott Walker guy because of not just the push for his beating of the unions, if you want to call it that, but breaking up of the government unions, but the fact that he survived it and he thrived in it, and he was able to win re-election with it. He was able to do something tough and make it stick, and then live to tell the tale, as it were. And those are the things I think politicians need to be reminded, is that doing the tough things, if they're the right things, is always rewarded by the voters in the long run, even if your political consultants don't think so.
Yeah, that's absolutely right. And if you look at Matt Bevin in Kentucky and Eric Greitens in Missouri, those two governors ran on a platform that said they would, if they got to be the executive of those states, their respective states, Kentucky and Missouri, that they would sign right-to-work laws, and they were elected overwhelmingly. It's really an amazing thing that, to your point, Joe, you said it better than I can. If they stand up for things that people believe in, they will do well. But there's been this perception, and it's a perception that's created because of the power and privilege that organized labor gains by having the ability to compel workers to pay dues or fees to be able to keep a job, that make them a pretty large political opponent. And if you look back at the Democratic primaries for president, you'll find, interestingly enough, and no one really pays much attention to it, the people they endorse don't usually get the nominations. Yeah. It's an amazing thing, even inside their own party, if you will.
Well, and we see this in the gubernatorial race here in Virginia. The current leadership party on the executive side, the Democratic Party, has pushed for a change in our right-to-work laws. Now, they don't have the legislative traction, given that the Republican Party holds the House and Senate. But even the Attorney General has talked about wanting to enforce right-to-work laws, even if they weren't necessarily part of the law of the Commonwealth of Virginia. I think it's a very important thing, because we've seen members of the Republican Party try to elevate right to work to a constitutional amendment, so that just the whims of a governor or a coattail or two leading to a change in the General Assembly wouldn't be able to have that undone, where it's been benefiting, as you mentioned, all these other states like Kentucky.
Yeah. Well, there's lots of questions about strategy on it. I think that the Commonwealth of Virginia has benefited dramatically from their right-to-work law, and not only that, but from the statutory prohibition against bargaining in the government sector. The idea that you have to go farther is, the constitutional amendment, Joe, is an interesting question. It's one where, a constitutional document is a larger principle document, and when you start writing additional things to a constitution, that makes me a little nervous. But for the first time, you're right, a statewide candidate, Terry McAuliffe didn't do this, Tim Kaine didn't do it, Mark Warner didn't do it, but the candidate now on the Democratic side has indicated that he's like to look at the possibility of repealing the Commonwealth's right-to-work law.
It's a fascinating time as Virginia team seems to be running north and a lot of other states are running south to right-to-work laws and benefiting from it as well, Mark. Mark makes, again, give the website so people can join you at the National Right-to-Work Foundation because I think people, if they don't know about your work already, should be finding out more about it and then being able to join you as well.
Well, thank you, Joe. Thanks for the opportunity to talk about this, and people can find us at nrtw.org, nrtw.org.
Well, I appreciate it, Mark. Thank you so much for joining us this week on Freedom and Prosperity Radio.
My pleasure. Thank you.
Up next, Wayne Cruz from the Competitive Enterprise Institute regarding regulatory classifications. I know it sounds wonky, but Wayne Cruz never lets it stay that way. We'll be back in a moment on Freedom and Prosperity Radio. Welcome back to this week's edition of Freedom and Prosperity Radio. Two of the most important things you could possibly have, although if you listen to some of the commentary this week, those are not guaranteed rights by the Constitution. No, they weren't guaranteed by anyone. They were given to us by God. But we called the winner in the Republican race in Mississippi crazy because of the Alabama race because he said that our rights come from God, and all the commentary went nuts there anyway. We all know it comes from government, and a man who chronicles how they give it to us in his programs and his reporting, and certainly every year with his annual 10,000 Commandments report. He is the amazing Wayne Cruz at the Competitive Enterprise Institute. Welcome back to the show, Wayne. How are you doing, sir?
Doing great. Thank you so much for having me. And yes, all your rights come from government. I'm here to give them to you.
Well, and I guess, your latest report details one of, and if you don't find humor in this, you just aren't trying.
We will.
Your report is what's the difference between major and significant as it comes down to red tape, and the nomenclature that our bureaucrats hide behind is stunning stuff, and why some programs can never be cut because they've gotten the right name attached to them and the right adjectives applied to what their business model is. Is that what you're talking about here, Wayne?
Yes, and I'm glad you brought me on to talk about this, and I'm glad you get interested in this idea because a lot of times folks' eyes will glaze over when you start to talk about government regulations, and sometimes mine do too. But put things in context with the scope of government right now. Back during the downturn in the economy, the federal government was spending $4 trillion, and now we're back to the point where we're spending $4 trillion again. Luckily, the markets are booming. The job numbers seem to be going up. Lurking behind all of that is still all of the folks out of work and who aren't looking for jobs and things of that sort.
Underemployed.
Exactly, underemployed and working. Yeah, part-time people who want to work part-time, or employers who would love to hire part-time, but they can't because once they do, all these new rules kick in, and it's a global phenomenon that way. And that gets you into the whole automation debate in the future. It's just a tangle of issues that regulation is behind a lot of, or will influence a lot of. But as you know, we started chronicling the numbers of regulations, pages in the Federal Register, the cost of regulations, and all this sort of thing, because we knew what the federal government spent, but what interested me and others was what the federal government was making the private sector spend and how that was affecting prosperity and freedom, as you talked about at the beginning of the show, and jobs and all of that. And so we started tallying it up. And, every year I've come on here several times and talked to you about, the Federal Register is just tens of thousands of pages long every year. And, last year Obama ended the year with a 97,000-page Federal Register. This year, so far, Trump's Federal Register is about at 45,000 pages, and it looks on target to be about 60. But remember, Joe, we talked about this before, Trump is to the extent the executive can do anything by himself without Congress, we've had these separation of power discussions on here too. But to the extent he can use the pen and phone to advance liberty rather than curtail it, as a predecessor did, he's been able to cut that flow of regulations back. And remember, since he's doing the 2-for-1, for every regulation in, 2 have to go. Yep. That has meant that this is one of the crazy things that I talked about in this new report about all the nomenclature. In order to get rid of a rule, Joe, you have to write another rule.
Yeah, that's
in order for
Munchausian.
Trump to cut a regulation, he's still got to write a regulation, and it's got to be published in the Federal Register. You want to do it that way, but you want to have a different categorizing system so we can figure out just what the heck is going on and what's been cut. But in any event, what happened was, you and I talked about 10,000 commandments and the thousands of rules, usually about 3,500 or 4,000 rules in the Federal Register. Of course, last year it was close to 5,000 rules. But in cataloging all of this, and with President Obama in his last term saying, I've got a pen, I've got a phone. If Congress doesn't act, I will act. Just a complete abrogation of separation of powers and checks and balances and all those sorts of things that we cherish. And in the Constitution, our founder always jokes the Constitution isn't perfect, but it's better than what we have now. And I think that's a great way of putting this.
Yeah.
But what we realized is it wasn't just President Obama doing things like, say, the transgender bathroom order, or regardless of what you think on immigration, of changing immigration policy unilaterally or waiving or non-waiving different parts of Obamacare on his own. But, Joe, the agencies were doing all of this stuff, too. And I noticed there were, from all of these agencies pouring out, were guidance, bulletins, notices, circulars, memoranda, administrative interpretations, all of these ways that agencies were regulating without writing anything down or without going through, let alone a law from Congress that the president signs, but not even the ordinary notice and comment regulatory process. Now the federal government is so much in the driver's seat. Our founder says the government's steering while the market is merely rowing. And it's true whether you're talking about the financial sector, now telecom with net neutrality, or electricity regulation, or financial services, and now healthcare, of course. So a lot of ways that the federal government is regulating without going through the notice and comment process. And so that got me looking at the so-called regulatory dark matter and cataloging that. And then as I did that, I realized even that the rules that we do count up go through have all of these weird names that the agencies can hide behind. So that's kind of the situation we're in, Joe. This week, President Trump was, in recognizing this, and of all of the things that have been so hotly disputed this year, the Gorsuch nomination, and then, of course, the budget now, which is under dispute,
tax reform
being debated, all of these things that have been occurring. The one thing that has happened is at least from the executive branch side, to the extent that Trump has got the agencies looking at regulations, there are some positive developments there. I think we can talk about this a second. I'll be quiet for just a second so you can steer this where you want. But it is it's the largest cut or slowdown, I guess you could say. You know how when you talk about the budget, you say it's not really cut, it's just growing slower than it did before.
Right.
This is the biggest cut we've seen in the flow of regulations, as far as I can tell so far since Reagan, because there's been nothing like this under the prior presidents of either party, where the numbers of rules and the numbers of rules getting put into the pipeline, the proposed rules, have been cut like they have under Trump. But it'll take Congress to act, and that's something we can talk about as well. It's not today, another time. But Congress will need to act as well to make this permanent. But at least we're on the right track. I think it's the right attitude.
Well, and let's get into this, because the bureaucracy seems like, because our congressional representatives, being so notably courageous, have often written very open-ended rules. You and I have chronicled them here, Wayne. They'll say, we want the Chesapeake Bay clean, and we're asking the EPA to go do that. Signed, Congressman Hooses. And he'll go out and make that his campaign flyer, but meanwhile, then the EPA gets to go to work and doing, as you said, for a few thousand pages of law, hundreds of thousands of pages of regulation get written, and so they fill in that matter. But they also seem to, if I'm reading your report correctly, put poison pills in here or tripwires that say, well, because it says this, you can't change it, because somewhere along the line, probably in the 60s, somebody said a major regulation can't be changed unless you do this, but a significant one can be changed if you do that. And talk about how they've used language like these cunning linguists they are to protect themselves.
It's really incredible. All the administrative state started 100 years ago, and then it really, with antitrust, and then it really cranked up in the 30s, and now it's become kind of sacred. It's very difficult to challenge it. Sometimes I joke about some of the regulatory reform proposals. I say, we're basically playing in the left's sandbox, playing in a sandbox on the left's beach, and trying to tweak these rules. And I noticed when I was going through, initially we had the rules and interpretive rules that were that were defined in the Administrative Procedure Act. But then with executive orders that came out from President Reagan, then we had major rules. And then under Clinton, we had significant regulatory actions. And then under George Bush, we started to have significant guidance. And all of these rules were getting redefined and defined in weird ways. And some meant the rule was $100 million. Some meant the rule just had a significant economic effect that was unspecified. Some major meant the rule had a large effect on competition or trade. And so all of these weird definitions for rules and nobody really agreeing on what they meant, I noticed that the category called economically significant that people would always say was the major category of regulations, the largest, most costly, isn't defined in legislation anywhere, and it's not even defined in an executive order anywhere. It's just a term of art that ended up being adopted, and now it's what we hang the entire hat of the regulatory state on. So it's just some incredible things like that, Joe, that I noticed, and it made me realize that this year we've had a couple of good things, along with Trump doing his executive orders that for reg review and 1 in, 2 out, things like that. The Congress at least has done his job. I'm not sure if your listeners are even aware of this, but they say do nothing Congress, can't get anything done. But the Congress passed the REINS Act, which was the major piece of reform legislation to say, okay, for these big fat rules, the fattest ones, they need to go back to Congress for an up or down vote. Major restoration of what governments ought to be doing, what the separation of powers and those kinds of checks and balances. Amen. A major important thing. They also passed Regulatory Accountability Act which would codify a lot of these executive orders that we're talking about and make the OMB review the regulations and make sure that things were straight. That normal humane cost-benefit analysis got done. So the Congress has passed these kinds of laws, but what I'm worried about is when they do it, they got to be careful about all of this nomenclature and make sure that they whittle this down so that when we are talking about the regulatory state, we can be talking about the same thing. We've got so many categories of rules and so many categories of dark matter that I'm worried about. If you imagine you pass a great piece of legislation, but then the agencies just go off and say, well, we're not going to call this a rule. This is going to be a memoranda.
It's an understanding. Yeah.
The big problem is the whole notion of the administrative state itself. Yeah. I don't think it's appropriate to the future of the country, and I don't think it counts as regulation. I think you have to have market disciplines and a lot of competitive pressures to make companies behave. I don't think you can just sweep all that aside and say, oh, if the agency just issues a rule and sets a cap or sets a standard, that's regulation. I disagree with that whole philosophy. So that's what I meant too when I was talking about sandbox on the beach. You can't just tweak this. You have to say, wait a minute, the administrative state and issuing guidance for drones or driverless cars or robotics or artificial intelligence, that's not the way you're going to get safety and secure development in those kinds of technologies. I've said this to you a lot before. Laissez-faire doesn't mean companies just get to run wild and do whatever they want to do. They've got to answer to their upstream business suppliers, their downstream customers, the Wall Street, consumers, the media.
Absolutely.
There are all these forces arrayed against companies that misbehave. We're pretending that only Washington political discipline is what governs anything, and I disagree with that. And so that's what I'm always fighting against.
Well, and you bring up a great point, but from a business standpoint, thinking that Washington is the only pressure I'm going to have to work with is actually good for me, because then I can focus my energies there, and as long as I've got my U.S. whatever a seal of approval, I can go forth and say, hey, I'm appropriate to do business here, rather than worrying about finding customers and finding suppliers and finding a market and getting a good location, all those other things. I just wait for the government to say, yeah, you're the guy.
You know what? That's an excellent point, Joe. I was just working on the Fraser Institute was putting together a book, a compiled volume on entrepreneurship, and we were looking at the question of entrepreneurship and the impact that regulation has on it. And one of the key issues we have is this: what you're describing, basically like rent-seeking type behavior and political predation. So many there are a lot of companies who would be happy to say, "Oh yeah, I can be the lead guy here if I just agree to these regulations, and it'll be regulated forevermore." That's what you got with the electric. You know how we talked before anything that was in government's hands at the dawn of the progressive era is our Fred Smith would always point out is still in government hands. Airsheds, watersheds, spectrum, things of that sort that should have been brought into the market process are now still under the control of government. And Joe, what you describe right now is a real threat, I think, with respect to some of the frontier technologies that are coming out now, that are about to come out now, whether it's the driverless cars or the drones.
Oh, just anything,
things of that sort. Because imagine what you described is just right. You can imagine that the Jeff Bezos, I don't say him specifically, but the Jeff Bezos of the world or the Elon Musks of the world would be delighted for the government to say, "Oh, you're the guy. You're the guy because you'll drop the package off from the drone, at 1 foot above the ground, and we'll give you a license, and you'll be the exclusive guy." Kind of like we did with the electrical grids and the telecommunications grid. We banned competition.
Absolutely.
The regulatory process of creating a public utility, creating it and misnaming it a natural monopoly, because there were no natural monopolies. You might have had a lot of wires going up and down the street. You might have had an aesthetic problem, but never a natural monopoly problem. There were a lot of competitors moving in. But we stand, I think, given that the government's already controlled the airspace, and here come the drones, and given that government's already controlled the roads, and here come the driverless cars, we're very at risk of what you just described. Rather than this being driven by a bottom-up market processes, we're going to get the FAA and the Department of Transportation and others dictating standards of industries that aren't even here yet.
Well, and I bring this up to my progressive friends when they start talking about the government, guaranteeing. And I love the way they leave words out. We started this talking about the deep state adding words as they see fit, but our progressive friends will conveniently leave words out, like they'll go to a news coverage and say, "We want internet service for the rural area," when really what they want the government to do is guarantee high-speed internet service, but that doesn't sell as much. Or illegal immigration is not the same as immigration, but they want to conflate that. And I asked one of the proponents of government utilitized internet service so that everyone can get high-speed internet and we can download Netflix. I said, how's that working? You're the same folks protesting Dominion and the Atlantic Coast Pipeline and saying that Dominion isn't listening to you, but yet you want the state to do the same thing to your internet service. And I don't understand the hypocrisy to that.
Mm-hmm. It's an excellent point, because you're exactly right. I recall that. I recall that during the electricity debate. We've always had this debate over telecom and net neutrality, and suddenly they want the government to do what they're fighting the government doing now. There's so many advances, and there's so many advances in capabilities with respect to internet. We were debating. I guess the net neutrality debate is back again.
Yep.
Republicans proposing some ideas that I think are extremely bad. I think Republicans saying no blocking, no throttling in 2017 is way worse than. We're not responsible for Title II in the Telecom Act on our side, but I think the Republicans doing something like that now is way worse than Title II, because we can get out of that kind of hornet's nest. But it's one of the strange issues that the left thinks the federal government can run these kinds of networks and expand this access.
Sure.
I said, what if the government had imposed net neutrality back when we were using dial-up modems at 28K?
Where would we be now?
Who would be investing in the internet, and who would be giving you the multimedia capabilities that we have now? It's a bizarre situation.
Well, it's as our founder, John Taylor, once said to me. He said, for a century, the phone company was a monopoly, and our greatest innovation was we went from rotary phones to touch dial. Is this just the human nature for impatience? Because a lot of these bureaucracies were created because we weren't patient enough to let the market do that to a business. We wanted swift punishment for a company that polluted a river or something along those lines.
Yeah, I think there is a lot of impatience, but I think you hit it more on the head a while ago when you said there are those businesses out there who do have those ends with the bureaucracies and with the power holders. Because remember, they've got these vast economic powers, these vast powers over the economy, right now, and it's too easy for them to create that alliance with the state and to create new public utilities. So I think that's it. But don't. I always say to you when we close these out, don't lose hope, because capitalism is still a very young system, in terms of human history, and we shouldn't expect that we would have gotten it all right yet.
No, absolutely.
It was easier to solve, property rights issues with respect to fencing in your land or who owns your mule or your car. Sure, it's going to be tougher with airsheds and watersheds and long and thin networks like telecommunications and what we're going to have with drones and driverless cars and new kinds of infrastructure. But the Republicans, or even the Democrats, because when we do have major regulatory reforms, Democrats are very, very much involved and very much on board. They were even in favor of the Congressional Review Act that was debated so much this year, the law that rolled back so many of Obama's rules. So you can get that. You can get to that point. You can maybe break up the regulatory problems into bite-sized pieces, like paperwork on the one hand, economic regulation on another, telecommunications on another, health and safety and environmental all separately, and work together on things. Because you were talking to your progressive friends. A lot of them don't want Uber regulated. They want to be able to use Uber. Sure. They want to be able to use Airbnb, and you kind of have some common grounds there that you can work from.
It'd be easy for me to be for net neutrality because it protects my business. I could be that going, because I'm old school radio. Net neutrality would shut down probably half the bloggers or podcasters and whatnot in that because you'd have to go through the story. So I would technically be protecting my business. So I'm taking a hit for the team as well, Wayne. Thank you for everything you do. CEI.org. We never even got into talking about Arendt or any of the bureaucracy, maybe for the next episode. But Hannah Arendt is one of our favorites here on the show. But thank you for what you do. When does the next 10,000 Commandments come out?
Well, thank you. The next edition, I usually put it out in the first quarter of the new year. So I'm looking at doing another one in early 2018. I'll try to take a look back at how Trump's year has gone.
Yeah, that'll be very interesting.
And sort of try to tease out the difference between what rules were actually revocations of rules. We haven't sorted that one out yet.
That's it. Well, thank you so much, Wayne. CEI.org, Wayne Cruz, 10. It's on Twitter at 10K. 10K
That's
Commandments.
Right, 10KC.
Yeah, 10KC. Thank you, sir. You have a great day, sir. And
thank you so much.
Thank you for listening to this week's edition of Freedom and Prosperity Radio. Speaking of bureaucrats and vogons, on behalf of all of us here at the Virginia Institute for Public Policy, so long and thanks for all the fish.